Have you ever, hesitated before posting something online, maybe worried about how it might be taken? Well, we're about to dive into a case from India that takes that feeling to a whole new level. It's a story where one single Facebook post actually led to an arrest, and it kicked off a huge fight for online freedom that went all the way to the highest court in the country. Yeah, you heard that right. It sounds pretty wild, but it's exactly what happened. Our story really kicks off in 2012, a time when this whole debate over what you can and can't say online became incredibly real for two young women who were arrested and put in jail, all because of a Facebook post. So, how on earth did it come to this? Let's get right into it. Part 1. A post, an arrest. Okay, so here's the timeline. It's November 2012. A major political figure passes away, and the entire city of Mumbai just shuts down. So two young women, Shaheen Datta and Reenu Srinivasan, do what a lot of us might do. They hop on Facebook and complain about the shutdown. A pretty normal thing to do, right? But what happened next was anything but normal. It was fast. It was shocking. They were arrested. Getting arrested for a Facebook post, that just raises a massive question. What kind of law could possibly allow that to happen? Well, that brings us to the real villain of this story, what I'm calling the annoyance law. The police were using this very powerful and very controversial tool, Section 66A of India's IT Act. Basically, it made sending messages that were deemed offensive a crime. And the punishment, this was no slap on the wrist. We're talking up to 3 years in prison, plus a fine. Now, check out the actual wording of this law. It went after anything grossly offensive or anything that could cause annoyance, inconvenience, or insult. But think about that for a second. What does annoyance even mean in a legal sense? Who gets to decide what's inconvenient? These words are just so subjective, so incredibly vague, and that's what made the law so dangerous. And this is a classic example of what legal experts call the chilling effect. See, when the rules are that fuzzy, you start to second-guess everything you say online. You think, could someone find this tweet annoying? Could they say this post is insulting? So what do? You start to police yourself. You self-censor, not because you've done anything illegal, but because you're scared you might break a rule you don't even understand. And that's how free speech starts to fade away. But this story was far from over. The public outrage over these arrests was absolutely huge, and it lit a fire that sparked a legal battle that would go all the way to the top. This brings us to part 3. The court strikes back. And get this, the person who led the charge against this law, it wasn't some famous lawyer or a big-shot politician. It was a law student. Her name is Shreya Singhal, and she took this fight straight to India's Supreme Court, arguing that a law like Section 66A simply has no place in a free society. So, the battle lines were drawn. On one side, you had Shreya Singhal and the petitioners. Their argument was clear. The law violates the fundamental right to free speech, it's way too vague, and it creates that chilling effect we just talked about. On the other side, the government pushed back, saying, hey, Parliament makes the laws, we need this to fight cybercrime. And they even argued that the vague language was actually a good thing, that it was needed to catch new kinds of online threats. So, after all the arguments, the legal showdown finally reached its peak. On March 24th, 2015, the whole country was watching as the Supreme Court got ready to deliver its historic and unanimous decision. And the court's reasoning was crystal clear. They broke it down perfectly. First, they agreed the law was unconstitutionally vague. Words like annoying have no clear legal definition, leaving them wide open for abuse. Second, they said its scope was way too broad. It was like using a sledgehammer to crack a nut, punishing perfectly legal speech along with the bad stuff. And third, they confirmed it created that chilling effect, making people afraid to speak their minds. And for those 3 reasons, Section 66A was struck down. Gone. So that's it, right? A huge win for free speech? Case closed? Well, not quite. The story takes a really bizarre and frankly disturbing turn right here in part 4, a law that won't die. This is where we run into this fascinating and kind of creepy legal idea, the zombie law. It's exactly what it sounds like. It's a law that has been killed by the highest court in the land. It's legally dead, but somehow it keeps shambling on, with police still using it to make arrests as if it were alive. And I'm not just talking about a theoretical problem. Just look at this number. In the years after the Supreme Court killed the law, researchers found that around 70 cases were still being filed using Section 66A. The law was dead, but its ghost was still haunting people.
This shocking reality, a dead law that refuses to stay buried, brings us to our final and I think most important question. It's what connects this specific case in India to all of us, everywhere, who live our lives online. Why this still matters.
So, what's the big takeaway here? On the one hand, the Shreya Singhal case was a landmark victory. It set a huge precedent that your speech online deserves the same protection as your speech offline. It said that any laws restricting speech have to be precise, not just vague catch-alls. But it wasn't a clean sweep. The court left some other government powers in place that are still debated today. And most importantly, this whole zombie law problem proves there's a huge, dangerous gap between a court ruling and what actually happens on the streets. And that leaves us with this final, nagging question. The court case was a monumental victory on paper. But when a law can be declared dead and still refuse to go away, it really makes you wonder. Is our speech online ever truly free?